Hello, everyone. Thank you for joining us. I'm Bob Goulder, a contributing editor with Tax Notes. This is the latest installment in our series, In the Pages, where we take a deeper look at some of the content that has appeared in our publications. And we have the opportunity to speak directly to the authors. And today, I'm especially happy about the material that we're going to cover. This is an issue that simply won't go away. And full confession, I'm not sure I want it to go away because it's a policy area that just cries out for a response from our federal government. We're talking today about citizenship-based taxation. Now, this is a sensitive topic, arguably, because we're talking about American exceptionalism, and I should specify that I don't mean that in the positive sense. This is an area where the whole rest of the world is doing something, I'm going to say, the right way, and the United States is doing it a little bit different, and there's some negative repercussions to that. I think, frankly, it's not fair to some folks, but we're going to get into all of this. So just at the very basic level, what is citizenship-based taxation? What's the alternative? Well, it's residence-based taxation. And if you've spent any time thinking about how governments tax individuals, you probably know about the benefits principle. It's this idea that you ought to pay tax where you live, which is where you use public services. This seems kind of self-evident. But the United States goes one step beyond that and says, we're also going to tax, in addition to residence, we're going to tax on the basis of citizenship. Now, whom might that adversely affect? It could affect American citizens, US citizens who, for one reason or another, choose to live overseas. Now, that might be because of their employment, or it might be because of family connections, or perhaps they've just decided to retire someplace warm and sunny in some other part of the world. After all, this is the era of economic globalization, and people move around. So now, what we're getting at here is there's an opportunity for double taxation, and there's also some very harsh compliance burdens, even if you can somehow get away from the double taxation. All of these issues were expertly discussed in a piece that ran in Tax Notes International in October. The title of that piece, if you have your database and you want to look it up, it's called A Simple Regulatory Fix for Citizenship-Based Taxation. And we're thrilled to have the three authors of that piece with us today. And allow me to introduce them. They are John Richardson, an attorney based in Toronto, Canada; Laura Snyder, an attorney based in Paris, France; and all the way on the other side of the world, Karen Alpert, a lecturer with the University of Queensland in Brisbane, Australia. John, Laura, Karen, welcome to the show.
Thank you.
Thank you very much.
So you heard the introduction, and I want to get to your article. And I love the fact that you had in your article a reference to pop music. Everybody knows about the band The Eagles and the famous hit they had back in the 70s, Hotel California. There's a line in that song that says, you can check out, but you can never leave. And it's become somewhat iconic. And conveniently, it relates exactly to what we're talking about here, because when a US citizen becomes an expat, they check out in terms of establishing legal residence in another country, but they don't necessarily leave the long arm of the US tax code. Can you elaborate on that metaphor and start to outline the scope of the issues here?
So really, it affects both the taxpayer and the IRS. So I'll cover the taxpayer side and let Laura talk a bit about how this impacts the IRS. So as a taxpayer, if you leave, or if you're not living in the US, you'd really like to integrate economically or financially in the place, in your new home. And having the US tax code around your neck the whole time makes it very difficult to do that. So you might want to save for retirement where you're living. But the US doesn't recognize that as a qualified retirement account because it's not organized under the Internal Revenue Code. Why would an Australian company give you a pension that qualifies under the Internal Revenue Code? So the US is not going to treat that as a qualified retirement account. That's just one example. There's all sorts of different things. Different countries have different ways of organizing businesses. In Australia, you might run your dental practice through a family trust. How am I going to put that on a US tax return? Is it a trust? Is it a corporation? Is it a partnership? What is it? these countries don't set up their legal structures, their investments, etc., with the US tax code in mind. And it makes it very difficult for someone who's living in those countries to integrate their life into that country financially while they're still subject to US taxation.
So we want to also look at why is this not a good thing for the IRS? And what the system in place today does is it says to the IRS, you need to administer a tax system on a global basis, not just on a national basis, but on a global basis. So what does that mean to administer a tax system on a global basis? Well, it means that you need to have IRS personnel that understand the tax systems of all the other countries where they're administering the tax system, where they're administering the US tax system, which is all the countries where Americans live around the world. So 100 and some, probably closer to 200 and some. You need IRS personnel that are trained to understand the systems of all of those different countries and how the systems of those countries interact with the US system. And you need them to be able to be trained to respond to taxpayer questions. You need them to be trained to perform audits. Today, that does not exist in the IRS. There's almost no IRS personnel that anyone would consider to have the necessary expertise, probably for even one country, let alone for more than one country. What else does it mean to administer a tax system on a global basis? It means you need a very wide range of forms and publications that are adequate to address the issues that are particular to each country and that are in the languages of the people that live in those countries. Today, all you have basically is publication 54, which is, a one size fits all for all countries and all languages, which really, is not enough. And what else do you need? You need an adequate way of communicating with all of those taxpayers living around the world. This means they need to have access to online accounts. They need to be able to phone the IRS. They need to have reasonable mail delivery, in-person visits. Today, none of that is possible with the IRS. The IRS closed all of its offices that it had in consulates about 5 or 6 years ago. You can't call the IRS on a toll-free basis from outside the United States. So, it's very difficult if you're overseas to get through to the IRS, even to get to somebody who then won't be able to answer your questions anyway. We've recently done some research on the Taxpayer Advocacy Panel and discovered that a lot of the mail that the IRS sends to overseas taxpayers takes 50 days, 60 days, 70 days, sometimes over 100 days to reach its destination. And the IRS will not allow people who live overseas to have access to an online account for security reasons, they say. It's very difficult to pay the IRS from an overseas bank account. Not impossible, but very difficult and expensive. It adds extra expense when you're trying to make the payment. And the IRS will not make payments such as stimulus payments or refunds to foreign bank accounts. So the IRS really struggles with all of these things, and I could go on. The IRS doesn't have the resources and sometimes the technological capabilities to administer a global tax system. And I've actually have seen this up front and personally, not well, up front, let's say, as a member of TAP, as a member of the Taxpayer Advocacy Panel. We have asked the IRS to make a lot of these things that I just mentioned possible. And TAP has asked for a lot of these things over and over the past few years. And the IRS almost always comes back and says, no, we can't do that, either because we technologically can't do it or because we don't have the resources to do it. And I think you have to look at this as all of these things that I just listed, these are not nice to have. These are pretty fundamental things that the absence of which violate the taxpayer Bill of Rights. And I can just cite some of them: the right to be informed, the right to know what to do to comply with tax laws, the right to quality service, the right to pay no more than the correct amount of tax, and then the big one, I think, the right to a fair and just tax system that includes the right to expect the tax system to consider the taxpayer's particular circumstances. So that's in a nutshell why the current system isn't just a problem for overseas taxpayers, but for the IRS itself.
Okay, John, anything to add to that?
Yeah, just very briefly. And I never tire of listening to Karen and Laura discuss this issue. But I mean, in summary, I think what they're saying is that compliance is impossible, administration is impossible. And I think what I would like to add is this, that actually the tax system imposed on Americans abroad because of the special treatment that governs anything foreign results in a completely separate tax system, where any American abroad is just trying to, live the same way their brother or sister is in some U.S. state, a bank account down the street, trying to run a small business, or, even invest in a mutual fund, is effectively subject to a completely different and more punitive set of tax rules. And this is something that I think is really not understood very well by the participants in the discussion on this. So, whether you look at the situation upside down, diagonally, or sideways, there are absolutely no winners and everybody is a loser.
Bob, could I make one more comment?
Please.
You mentioned in your opening, you talked about how a lot of Americans choose to live overseas. It's true. A lot of Americans do choose to live overseas, but not everyone who is considered a U.S. citizen chose to live overseas. I think there's some important categories of people that we have to remember. There are people whose parents were in the U.S. At the time when they had a child, but neither of the parents were U.S. citizens. And they left the U.S. when their child was still very young, sometimes in diapers, to return to their home country. Those people you can't say really made a choice to leave the U.S. And then you also have people who were born overseas to at least one U.S. citizen parent who then had the right to U.S. citizenship as a result of that. Well, those people have never lived in the U.S. So how do you say that they chose to live outside of the U.S.? They made no choice. And the other thing I would want to add, I think it's very important to keep this in mind. Leaving one's country is a human right. You will see it in multiple, United Nations human rights instruments, including ones that the United States has signed and ratified. So it's not a luxury to move to live in another country. It's a human right to do that.
Very well said. I'm glad you mentioned that. That category of person is sometimes referred to as an accidental American.
Correct.
And arguably the poster boy for that is the current Prime Minister of the United Kingdom, Boris Johnson, the guy with the funny blonde hair who you see talking about Brexit all the time. His parents were British, of course, but they were, I think, affiliated with Columbia University in New York City back in the 60s when Boris was born. And like you say, he moved away when I think he was still in diapers or something like that. And lo and behold, by virtue of being born here, he becomes a U.S. citizen. For tax purposes. And he found out about it because he sold some little cottage somewhere in the English countryside, which wasn't taxable under British law. But lo and behold, he gets a bill from the IRS saying, you owe Uncle Sam capital gains on the sale of that little cottage you had in the English countryside. And it just makes no sense. It makes no sense. But we need to move on. But thank you for mentioning that about the accidental Americans. Okay, now we're going to get in the weeds here with some statutory analysis. Our listeners and readers, they all know about the Internal Revenue Code, but there's another statutory body of work that's described in your article, the INA, the Immigration and Nationality Act, which goes back many decades, and that has its own rules about nationality and citizenship. Who wants to take a shot at describing some of this dichotomy between the tax code and the INA?
Sure, I'll start with that one and invite Laura and Karen to join in. This is a complicated and fascinating and evolving area of law. And I guess I would begin by saying that any taxes and the taxes on the basis of citizenship, may or may not define tax residency in terms of the nationality rules. But for years, as went somebody's U.S. citizenship status, so went their taxability as a U.S. citizen. Now, we have a statute, the Immigration Nationality Act, which does a lot of things. One of the things it does is it defines who is a U.S. citizen, and that's how the accidental situation has been created. It also defines relinquishing acts, ways that somebody can lose U.S. citizenship. And the way the statute was written prior to 1986 was that there was automatic loss of citizenship if one, for example, became a dual citizen, in earlier years voted in another country, oath of, various types of things. What happened was, though, and this is very, very interesting, that the 14th Amendment, as you know, says that anybody born in the United States is a U.S. citizen, born or naturalized is a U.S. citizen, basically. In a case called Aforium, which reached the Supreme Court of the United States in 1967, and incidentally, the lawyer, Aforium's lawyer, was the niece of Justice Brandeis. Okay, I mean, this was, I think that, this was a case that was long in the making. But in any case, in a 5-4 decision, the Supreme Court of the United States overruled an earlier decision called Perez, and basically focused on the 14th Amendment guarantee of citizenship, and used that to rule 5-4 that the U.S. Congress could not have legislation that automatically and forcibly expatriated people, right? I always use the phrase de-citizenshipized them because it's easier to understand. Now, the United States, as far as I'm aware, is the only country I know of that actually defines citizenship in the Constitution. I mean, there are all kinds of countries that say, well, if you're a citizen, you have the right to enter the country. But what this did was essentially expanded the number and type of dual citizens of U.S. citizens tremendously into the realm of dual citizenship, to the point where now they ignored Aforium for about a decade. Then there was another case, Vance versus Terrace, another Supreme Court decision that read the Riot Act to Congress and the State Department again. And basically during that period and from that point, these expatriating acts were null and void with respect to loss of citizenship, absent an intent at that time to relinquish U.S. citizenship. So all of a sudden, people who would never have been considered citizens under U.S. tax law, not because of a change in tax policy, but because of a Supreme Court interpretation of how the Immigration Nationality Act interacted with the 14th Amendment, all of a sudden became U.S. citizens. And therefore, absent a rethinking of this from the perspective of Treasury and Congress, subject to U.S. worldwide taxation. And these are the unintended consequences of this kind of stuff, right? And it was sort of like, I wonder, if somebody had sat on the steps of the Supreme Court when that decision came down in '67, they might have said, boy, you better be careful what you wish for.
Yeah, you have the case of people going, say, up to Canada to escape the Vietnam War draft and naturalizing as Canadian citizens eventually and being told by the consulate, you do that, you're going to lose your U.S. citizenship, but never having, say, a certificate of loss of nationality actually, prepared for them. They think that they've lost their U.S. citizenship, and now there's this court case that says, "Oh no, you didn't. If you didn't intend to, you haven't lost it." And now they're all confused. Are they U.S. citizens? Are they not? Are they subject to U.S. taxation? Are they not?
They're not.
They're not, because they would have intended. But you still find a lot of professionals that are trying to convince them that they are.
Okay, and I will commit to this publicly, there is no doubt in my mind that this group of Vietnam people and this group of professors who came to Canada in the late 60s and 70s naturalized as Canadians with the intent of relinquishing U.S. citizenship. There is no possible way that they would not have understood that that was the consequence. Impossible. That's the first point. The second point is, and I think this is very important, is that under the Immigration and Nationality Act, relinquishment of citizenship is not dependent on having a certificate of loss of nationality. It never was. The
And
reason
it's
this
not
was
dependent on telling the US that you've done it.
I'm sorry?
You don't have to tell the US that
Well,
you've
yeah,
done.
well, that's exactly
Yeah.
right. Of course, now, since 2004, the creation of the tax citizen, right, you know, which is another topic altogether. But the fact that there was no requirement to tell the State Department was the reason for the 2004 amendments to the Internal Revenue Code, which resulted in the creation of the tax citizen, so to speak. So this is a really, I mean, this is a fascinating, it is a complicated area. It is an area where, my God, people have got to be careful.
You know, I'm sure somebody listening to this might think, well, what other country has citizenship-based taxation? And over the years, you may have come to some conclusions yourself studying the tax regimes in other countries. I've found very, very few examples of any other country doing this. The one country that comes to mind is sort of an out-of-the-way place. It's Eritrea. You know,
Yeah.
relatively small country. I
But-
mean,
but-
nothing against the place, but
Their brand of citizenship taxation is very different. Flat 2% tax on everything. We're not going to try and get into, you know, trying to apply the domestic tax law on someone who's living overseas. There were
Yeah.
also several countries that had citizenship taxation and got rid of it. Notably the Philippines, which inherited it from the US, having been a US colony. And they found that it just didn't work.
yeah. I also came across a reference that France has a type of citizenship-based taxation, but only when their citizens move to Monaco, because they wanted to prevent wealthy French folks from just moving across the border from, say, Nice to Monaco and being outside of the French tax code. But that's not the same as saying that they have a blanket policy of citizenship-based taxation. So really, again, to the point of U.S. exceptionalism, we're the only folks that's doing this. Residence-based taxation, unambiguously, is the global norm. And this is a good setup for the next question. Congress, let's fix it, guys. What's the hang up? They must know about this. Certainly, it's only reasonable to assume that the legislative branch has heard of all these grievances, perhaps even welcomed them with some degree of sympathy, but then said, well, we're not sufficiently motivated to do anything about that. Now, in your article, which again is excellent, and I encourage everyone to read it, you explain some factors. I think there were 4 factors that explain or they get to this legislative apathy, I'm going to call it. What's Congress's hang up?
Well, definitely there are members of Congress that are aware of this and their staff. And then there are others that are less aware. That's my personal experience, having actually traveled with a delegation from the Association of Americans Resident Overseas and actually speaking to different staffers of different members of Congress. Here's the 4 reasons why I think it's very difficult to get Congress to act on this. The first one is there's the myth of the wealthy American expat. There is this idea that if you are American and you live overseas, well, how could you be overseas if you weren't wealthy? How did you even get overseas? And why would you live outside the United States? What legitimate reason could you have if it isn't to avoid US taxation? And there's a real prejudice against Americans who live overseas on that basis. And so I think it makes it very difficult for members of Congress, for their staff, and for the public at large to have sympathy, to get past that wall of prejudice, to understand that we are just ordinary people who want to live ordinary lives, and we can't because of the extraterritorial application of these laws. I think an extension of that, and what our second reason is that even if you have policymakers, be they in Congress or outside of Congress, who themselves might understand what the issues are, they'll also understand that others don't understand it. And so if they stick their necks out and try and make changes to these laws, they will be perceived as trying, another tax break for the wealthy, instead of just helping people actually be able to live normal lives. Certainly, I saw this when we were meeting with the staffers, which is, you live outside the United States. You're not really part of our constituency. Even if you might even be registered to vote in our constituency, you're not really a member of our constituency because you don't even live here. So I don't see why I'm going to spend my precious time and resources helping you, because that's taking time and resources away from my real constituents. And I think, you could even say that you could go a little further with that attitude and say, well, if you live overseas, you're not even worthy of Congress's time and attention. And then I think the fourth reason is, and this is a very widespread misperception, and this goes back to what Karen was talking about at the very beginning. There's this idea that because of the foreign earned income exclusion and foreign tax credits, well, in fact, there's no problem. Because of those things, you don't pay any tax. So what's the problem? What are you complaining about? And that misses a lot of problems, in terms of what it means to file a tax return, even when you don't owe any taxes. And it misses what happens to unearned income, to welfare benefits, to capital gains, to pensions, all of which are very serious problems for Americans living overseas that are not helped by the foreign earned income exclusion, by foreign tax credits, or by tax treaties.
I can't help but be curious how such a piece of legislation would be scored. If somebody introduced a bill and said, okay, we're going to just abandon citizenship-based taxation and follow the global norm and tax on the basis of residence because it's better for people and better for the IRS and better for everyone, how would that be scored? I mean, I don't think they're collecting a ton of revenue, but they're just creating a lot of headaches for people.
They're certainly not collecting a ton of revenue. I mean, if you look at the IRS statistics on the IRS website of returns by geographical area, you find that the returns filed from outside the US, more than half of them have zero tax liability. Okay, and those outside the US, that includes all the military stationed outside the US. They're not collecting a lot of revenue from this. We wrote a blog post or something a while back on this very issue, because we think that you shouldn't be worrying about scoring it. When you've got a moral issue like this, where you're taxing people who don't even live in your country, if it's the right thing to do, why should you be worrying about the cost? You just do the right thing.
And I think you'd also have to take into account all of the expenses the IRS does not incur, because it does not actually administer a global tax system the way it should.
One of the things that I think might be useful to add, not only to this discussion, but to sort of the consciousness or lack thereof of Congress, is this: that when people talk about this problem, the focus always seems to be on, people who identify as Americans and lived in the United States and for some reason or another, taken a job outside the country. The bigger long-term problem here, though, is the imposition of worldwide taxation on people who always have been and always will be tax residents of other countries and never will and never have lived in the United States. Some of them don't even speak English. And I think this is the real moral issue here. I mean, I think that, reasonable people can disagree about whether Americans who move 5 years, out of the United States should pay US tax. I think that people can disagree on that. But is it really possible to disagree on the statement that people who never lived in the United States, have nothing to do with it, don't even speak English, and all their income is non-US source, should not be subject to US worldwide taxation? I think that's the way the question really needs to be pitched here. And secondly, to add to what Laura was saying, now my experience with this is more limited because although I've been to Washington, I have not done the lobbying that she has. But I don't think that people understand, and I mentioned this earlier, that it is not the same tax system that is imposed on homeland Americans. It's a completely different and more punitive tax system. I mean, Americans abroad will always pay higher tax than a similarly situated homelander because their circumstances are considered foreign. It may be a direct tax, it may be brutal compliance costs. You know, they're almost certainly to walk in inadvertently into various aspects of the infamous anti-deferral regimes, the PFIC rules, the CFC, you know, this sort of stuff. It is, I mean, this whole thing is, it's obscene and it benefits nobody.
Well, okay, then let's talk about how to fix it without going through Congress, because it sounds like the congressional apathy might not change for all the reasons that you've outlined. And after all, the title of your piece is a regulatory fix, a simple regulatory fix. So let's go to that. What is the heart of your proposal here for fixing this through the Treasury Department and just ignoring Congress?
Right. Okay, I'll start, and then Karen and Laura can add. You know, it took me a few years of being involved in this issue before one night, I guess suffering from insomnia, I actually thought, well, why don't I read the Internal Revenue Code? Surely that will put me to sleep. And actually, this is true. And, you know, I began with Section 1. And, you know, if you listen to people talk about this, you know, you would get the feeling that the Internal Revenue Code specifies citizenship-based taxation, but it doesn't. Section 1 defines U.S. tax residency in terms of every individual, probably including your dog, your parrot, every individual on the planet subject to worldwide taxation unless you are a non-resident alien, right? So every individual. Now, I do acknowledge that there are provisions in the Internal Revenue Code that talk about U.S. citizens, but usually these are for different purposes, right? You know, defining people for, you know, for different reasons. So I thought about this, and then I looked at the regulations, and interestingly, the Treasury regulation defines individual as a citizen or a resident. And that actually leaves certain kinds of people out, for example, nationals. But even if it, you know, whether it leaves people out or not, you know, then I got to thinking, well, they define tax residency in the estate and gift tax regime, for example, in terms of domicile, right? I mean, there's nothing about, you know, the word individual that necessarily compels citizenship or even compels a certain, you know, different kinds of residency. There are many, many different ways of defining tax residency in the world. So my point is that the root of the citizenship taxation, although there may be historical proof for it, in terms of the current interaction between the Internal Revenue Code and the regulations, it's actually a Treasury regulation that defines tax residency in terms of citizenship. Now, as we said in the paper, clearly it is the view of Treasury that they can define tax residency because they've already done it, right? Otherwise, the only thing anybody would talk about is, are you or are you not a non-resident alien? So they've already done it, and they can do it again. And our thesis on this is, our proposal is that what they should do, of course, is stop defining U.S. tax residency exclusively in terms of citizenship or residency, but rather create a new category, which they clearly think they can do, of what we call the qualified non-resident. You know, maybe we'll talk about what that would mean, but the point is this, that it is fascinating to have this realization, but the Internal Revenue Code does not, in Section 1, define this in terms of, it defines it in terms of individuals, with the carve out being non-resident aliens. Treasury then defines individuals as citizens or residents. They don't have to do that. They can have domicile as they do in the estate and gift tax regime, etc. That's what should happen.
Karen, Laura?
Yeah. So, you know, when these Treasury regulations were written at first, that was back in the 50s and 60s, right? When citizenship was, you know, you were either a citizen or you weren't. I mean, you were either a citizen of the US or a citizen of another country. Dual citizenship wasn't acknowledged, wasn't accepted. So, you know, what Treasury had in mind when they said, or citizen, was that a person could only be a citizen of one country or at a time. And if you can only be a citizen of one country at a time, maybe it makes sense to say, well, if you retain your citizenship, you've retained some sort of tie to the country. And on the basis of that tie, we might have jurisdiction to tax you. But when you start getting into a world of more global mobility and dual citizenship, then, you know, someone remaining a citizen of the United States it doesn't imply nearly as close a tie as it would if there was no dual citizenship. So someone who's, you know, dual US Australian citizen living in Australia, why should their US citizenship be the one that matters for taxation? Why shouldn't their Australian citizenship be the one that matters?
I don't have anything to add other than, you know, I think all of what John and Karen has said is consistent with the fact that the IRS has never set itself up, had the resources, the expertise that's needed to administer a tax system on a global basis, which is entirely consistent with the explanation that John and Karen just gave.
Yeah, if I can just kind of add, like, what seems to have happened here is that, I mean, let's assume, okay, for the sake of argument, that, you know, the intention of all this really was, you know, to tax citizens, which, you know, I'm not entirely sure, but the problem here is that both citizenship and taxation have changed enormously, right? We now have dual citizenship. It's very common, but let's also add in here how much the US tax code has changed over the years. You know, I mean, basically, you know, as you know, starting in the 60s with the CFC was the beginning of this, you know, massive labyrinth of rules that we'll call the anti-deferral regime and the reporting. None of this stuff even existed at the time that these rules were sort of conceived, right?
True.
And I think you'd have to add to that, when all of these rules that penalize anything foreign were adopted, I think it's safe to assume people living overseas and actually doing those things because they live overseas weren't even thought about or contemplated. You know, when they adopted the rules for foreign trusts or PFIX, I don't think anybody adopting those rules had in mind, oh, wait a second, we've got citizens living overseas for whom these are not foreign.
Or
so
even the recent 2017 Tax Cuts and Jobs Act, you know, the GILTI provisions, for example, transition tax. I mean, it's, you know, I mean, I couldn't prove it, but I think it's fairly obvious that the reality existence of Americans overseas was not considered in this type of discussion, which is all the more reason why, you know, I think this has got to go. Was it Rawls or was it Dworkin who wrote this essay on equality, saying the equal protection means the equal care and concern of the legislature? It was one of the great legal philosophers. I never understood that, by the way, until I started thinking about citizenship taxation. Then all of a sudden it made sense to me, because the reality is that Congress does not think about Americans overseas, nor does Treasury, yet they're making these rules that impact all these people.
Well, and then think about the citizens overseas. So I've talked to lots of people who moved over here to Australia in the 60s and the 70s. They married here, raised families. Were they thinking about how the US was changing the tax laws? No. They had no clue that CFC rules maybe have gone in if they'd come in the 50s, or the passive foreign investment company rules in the 80s would have been maybe after they came to Australia. They may already have had those types of instruments. And, you know, all of a sudden the US is making laws that affect them, but they have no clue because they're not paying attention to what's happening in the US.
Well, and they couldn't understand the rules anyway, even if they wanted.
True enough.
This is another big part of the problem, is that, you know, the situation for overseas Americans is extremely difficult. There's no question. But ultimately, their fate lies in the hands of the advisors who they use. And this stuff is really hard. There is not a huge critical mass of really, really good advisors out there. So a lot of times, not only do they get kind of sucked into this, but they end up being treated far worse than they need to be.
John, a while ago you mentioned TCJA and the transition tax and the GILTI provisions. I suppose we don't need to talk about the participation exemption per se, but our listeners are so tuned in to anything related to TCJA, even though the statute's been around a while now, it still feels very new in the sense that we still have regulations coming out and so forth. Could you elaborate, and Karen and Laura join in, elaborate just a little bit on TCJA, because it always struck me that, like, in any tax reform exercise, you're going to have proverbial winners and losers. But it seems that TCJA was especially harsh on Americans overseas.
Yeah, sure. I'll start, and I'm sure that Karen and Laura will have all kinds of good stuff to add. But okay, let's start from the principle that homeland Americans generally do not carry on business through corporations. Generally not. Okay, I mean, there has to be a really specific reason. In other countries, let's use Canada where I live, it is very, very common for people to run businesses, carry on businesses through small incorporated companies. Okay, and the range is tremendous. I mean, these could be people running a yoga studio, they could be people running a dental practice. I mean, I basically I help with expatriation. I've expatriated a lot of people with small businesses over this issue. But the reason they do this is because it makes sense in Canada's tax system. Canada has high tax rates. For example, with doctors, instead of giving them a general pay increase, what they did was they created tax benefits by creating provisions for them to incorporate, et cetera. But my point is this, that in Canada, at least in other parts of the world, these small business corporations are actually private pension plans. That's what they're intended to be. That's what they are. Also, this is not an issue of money coming back to the United States at all. These are people who permanently live outside the United States. They're mostly dual citizens, et cetera. So the Tax Cuts and Jobs Act comes along, and basically, I'll give you an example. So what it says is that a percentage of your retained earnings has to be forked over to U.S. Treasury. Okay. Now, what this means is that unless they essentially liquidate a part of the company, or this is past tense now, liquidated a part of the company to create appropriate tax credits, they're absolutely subject to double taxation on this thing, number one. Two, where do they get the money to pay this? Okay, it's a non-realization event. And, I'm not making this up. I have talked to people who've been hospitalized over the strain of this type of thing. I have talked to people who had recently retired who had to take out massive mortgages on their homes to be able to pay this. I mean, the bottom line is that everything they did to responsibly save for retirement was destroyed by that particular tax. I mean, it is shocking, unconscionable, indefensible. Now that's punishing them for their past, right? As a great Templeton Mutual Fund used to have an ad that say, proud of our past, confident of our future. So I'll use punishing you for your past, and now we'll bring in guilty, right? Which is to destroy your future, to destroy your ability to use the very tax and financial planning mechanism created by the government of Canada so that people without normal pension plans could retire. Basically, that operates to take that from them, right? Because, see, the reason, the US tax rates are not as high as rates in some other countries. And that's part of the reason why, people use corporations, or I think in Australia, trusts. But, the problem is that these people are subject to a completely different set of tax rules where they live. So they end up getting by far the worst of both rules. But the bottom line is that this has absolutely destroyed the lives, and that's putting it neutrally, of a lot of people.
It's also a really good illustration of how the US tax code hits people differently depending on where they live. So in Canada, they're using the corporations as retirement plans. In countries without a totalization agreement, they're using the corporations instead of being self-employed because they want to avoid the US self-employment tax. They're already paying the equivalent of Social Security where they live. Why should they be paying self-employment tax on top of that? So countries like Israel, which has no totalization agreement, all these small companies that would be normally like Schedule C self-employed businesses, they have to incorporate to avoid the self-employment tax. And then TCJA comes along and says, oh, any, income that you had retained, well, we want a certain percentage of that. But the US had almost forced them to incorporate by not having a totalization agreement.
Yeah, that's true. And I would add on the whole transition tax thing, they're well aware of the problem for small individuals because the Chapter S people got a permanent deferral on it. And this is another reason why they have got to stop doing this. They have got to stop it.
And
There's
even
no way
in the
that this-
regulations, they're saying that we don't have to worry about Regulatory Flexibility Act or anything like that, because how can a small business be a CFC? How can someone who's not wealthy own a foreign corporation? And
Because
tell
they're not
that
wealthy.
to the hairdresser that has to incorporate because there's no totalization agreement.
Yeah, I think in summary, as I listen to Karen talk about this and everybody asked the question somewhat differently, I have a feeling that from a US perspective, although they realize that other countries have taxes, I don't think they realize that the tax systems of other countries work differently. And that's the problem here, really.
I'd like to just add something briefly to what John and Karen said. What I've seen is, generally speaking, the US rules that have an effect on businesses outside the United States. Well, before the Tax Cuts and Jobs Act, and still today, you'll see a lot of Americans living overseas who create businesses. They will go out of their way to make sure that they don't own more than 10%, so that they don't have to comply with the just the informational filing requirements. Now, some people can do that. For other people, for whoever it is, you better find people you trust to do that, and not everybody can do that. And people shouldn't have to do that when it's their businesses. And then what you find with the Tax Cuts and Jobs Act is suddenly Americans that were already a liability as a business partner, it's clear that they are liabilities as a business partner. Having an American as a business partner destabilizes your business. And you don't know what the future is going to bring. You don't know what new laws are going to be adopted that are going to make your business even more destabilized. So you see a lot of Americans simply being turned away. People don't want them as business partners, and they lose opportunities because of that.
This is real. I have helped people renounce where the very specific motivation was that they were not permitted to buy into a business unless they got rid of their U.S. citizenship. And these are small businesses. The one that comes to mind was it was like 5 or 6 bed and breakfasts in a resort area or something, right?
Okay, let's move on now. That was an excellent discussion of TCJA, but no conversation about citizenship-based taxation would be complete if I didn't mention the 2 F words. I think you know what they are: FATCA and F-bars. And don't discuss them in front of children because it'll give them nightmares. If TCJA was harsh and unfair and deplorable as it relates to U.S. citizens overseas, how do we even begin to approach this issue? I mean, F-bars, FATCA, they have a purpose. We understand, we don't want people playing fast and loose with the voluntary disclosure systems. If you're a millionaire sitting in Palm Springs and you've got an account in the Cayman Islands, yeah, maybe there should be some way to require that this person actually discloses the investment income from an offshore account. But there's a big difference between something like that which is justifiable and what we actually have. So who wants to take the ball and run with it as this relates to citizenship-based taxation and FATCA and FBARs?
Well, I would like to make a brief statement and then invite anybody to join in. Those things they are the F words. They're horrible. They're deplorable, but they pale in comparison to the actual tax rules. These are reporting requirements and they are awful. Make no mistake, but they do not in and of themselves prevent people from retirement planning. They don't confiscate assets unless it's a penalty provision. So I think that there's somewhat of a separate issue. If one were to redefine the issue of who is a U.S. tax resident, and we give a proposal for how to do that, then presumably that would take care, or at least it opens the door to taking care of the FATCA and the FBAR thing. One other point that I'd like to make before inviting Laura and Karen into this is that yesterday I have my greatest revelations when I read the Internal Revenue Code, or reminders, but I was actually looking at the statute, and it seems to me that Treasury has the authority to basically exempt Americans abroad from certainly the FATCA and the Internal Revenue Code. And there is no doubt in Title 31 in the Bank Secrecy Act, they also have the regulatory authority to exempt Americans abroad. They also, by the way, have the authority under the Internal Revenue Code to with respect to foreign banks, to tell them that if somebody provides a certificate of tax residency in their country, that they can be exempted from the account reporting thing as well. So it's a bad problem, but I think the way to deal with the problem is to deal with the citizenship taxation, because even if you were to get rid of FATCA and FBAR, you're still left with these tax rules.
Or you could keep FATCA and FBARs and just make them more rational regimes by changing citizenship-based taxation. Is that it? I don't want to put words in your mouth.
Or both. I mean, the whole thing is just, it is a Kafkaesque nightmare that people, the real problem, Mr. Goulder, is this, that I don't think that for anybody who has anything more than a job, with a salary, I think there are only various degrees of non-compliance with this system. I don't think it's
possible it's certainly not possible to know that you've complied completely correctly. It's just not possible. It's too complex.
Yeah, and I would add at any price, even if you were to turn over all your income, you still have the risk of some kind of PFIC, inclusion.
Oh,
right?
Well, the whole 3520 debacle last year.
Exactly.
Where everybody was, the IRS kept putting out $10,000 penalties for people for not filing 3520A, which if you read the IRS instructions, it sounds like that you can file it with your tax return, but they were saying, no, it had to be filed in March. And therefore everybody that filed it with their tax return filed it late, $10,000 immediately. And everybody was just following the same rules they'd been following for years.
Well, this is again, I really believe the IRS is actually the single biggest victim of this. They're charged with something that is simply impossible to administer. It is impossible to understand. Really, this has got to go. It has, for the sake of everybody, for the sake of the integrity of the U.S. tax system, it has to go.
Yeah, so when you get back to FATCA, and there's real problems in Europe, I think, with FATCA, in terms of the relationship between the US and Europe, because FATCA, on the face of it, violates the data protection laws in Europe. And the European Parliament, at least, has been going over this for years. They've got reports, they've done resolutions, etc. to try and get European governments to stop sending personal data back to the US of European
There was
citizens.
a hearing on this just yesterday, by the way.
They did.
Just
They had a
yesterday.
hearing just yesterday on it. And so it's a problem. You've got people in Europe who are being denied bank accounts because they don't have a social security number. Well, if you were born in the US before 1986 and left the US in diapers again, you didn't have a social security number. You can't get a social security number right now because all of the offices are closed due to the global health crisis. You can't renounce citizenship now because all of the consulates are closed. So you've got somebody whose bank is sitting there looking at a deadline that they have until the end of this year to come up with a social security number, or the IRS is going to start withholding. And they're telling their customers, we need your social security number or a certificate of loss of nationality. And you can't get those things now. And so this is a real problem.
Yeah, well, what you're emphasizing though is the effect of this on, people who really don't consider themselves to be Americans, right?
That's true. And also it's another instance of where the country you live in makes a difference. Europe, it's really hard to get a bank account. Australia and Canada, much less so.
This has an effect on people who do identify as Americans. FATCA and FR does. What
It
you
does,
see is,
but the people without social security numbers generally would be people who don't identify.
yes, absolutely. And I would accept that they have a bigger problem for sure. But what you find is a lot of Americans who are financially dependent on their spouses who are not Americans, they find themselves taken off of the financial accounts so that those accounts don't have to be reported. And so what you are doing is making those people who are already pretty financially vulnerable even more vulnerable. They're not entitled to assets like real estate. They're not on the bank accounts.
Okay, well, we know what happens when Treasury takes bold regulatory actions. It is sometimes subject to challenge in the courts. Countless examples of this. I think the debt equity regulations for Section 385 are some of my favorites. But so I'm just thinking here, would there be any litigation? I mean, who, apart from standing issues, who would challenge this? If Treasury did what you said and promulgated these regs with proper, notice and comment and jump through all the procedural hoops, who's likely to challenge this? I'm hard pressed to really think that there's a constituency out there who's going to say, no, don't do that for these expats. Am I wrong?
I think you're right.
I think the real beneficiaries of the current system is the compliance industry. So, I mean, because they're charging a lot of money to do these returns that show zero balance due.
But what would be the basis of the argument?
No, they wouldn't have any basis. They wouldn't have any standing, clearly. But there would be the ones that would be lobbying, perhaps, to keep this from happening.
Yeah, it just seems to me that everybody would benefit. The world that sees itself as nothing to do with America would benefit. I don't see any reason at all to, and let's not forget here that, if the issue is somehow that ultimately the issue is the taxing of foreign income, right? That is foreign to the U.S. because U.S. source income is always taxed anyway. But, there's the foreign tax credit regime that's going to, knock out a great deal of any potential tax the U.S. could collect because it's already taxed in another country. I mean, why not just rely on the foreign tax credit regime? I mean, if people are paying no tax, they're going to pay full U.S. tax. If they're paying tax in France, of course, that's going to be offset. It's as though it's an imaginary problem also.
I can't see in litigation how someone, I really can't see that, how someone would have standing. But I can see a kind of public relations issue where, what would come back is this myth of the wealthy American expat, the prejudice against the wealthy American expat, and making this kind of change. I could easily see people painting it as, oh, you're giving more tax breaks to the wealthy. You're enabling people to run away, escape their U.S. tax obligations. I can't imagine that someone wouldn't paint it that way. But whether you'd succeed in any sort of court case, that I really can't picture.
But who would be the group? Who would be the group who would, write a brief, respond to the request for public comment? I mean, this is an interesting question. Yes, who would be the group?
Yeah, I can't think of anybody that would be motivated to challenge that. I can only think of people that would benefit from it, apart from perhaps the compliance industry that Karen alluded to. But that should not be an obstacle. Well, we are approaching the end of our time. There's still some issues that we haven't got to, issues related to use of trusts and mutual funds and so forth. But all that's in the article. Again, it's an exceptional article. It ran in Tax Notes International in October. It's titled "A Simple Regulatory Fix for Citizenship-Based Taxation." Read it, circulate it, send it to your friends and family, send it to your grandmother, send it to send it to your congressman. Christmas is coming. Copies of the PDF make a fine stocking stuffer. But this is an issue that won't go away. Something tells me we might be discussing this again in a year, although hopefully in the context of a remedial measure being taken by Treasury. Any final comments before we sign off? John, last words?
I just want to thank you for the opportunity for this discussion. I think it's been a good one, and I think that the fact that Tax Notes would have this discussion and publish that is great news. So thank you for that.
Karen?
Yeah, I have to echo. Sorry, I have to echo what John just said.
Yeah, definitely. Thanks for the opportunity. This is really kind of a sleeper issue that a lot of people don't really understand how difficult it is to try and comply with US tax laws when you're permanently living overseas.
Yeah, and if I may, Mr. Goulder, you've been a great moderator because, the reality is that to moderate the discussion, you have to have some understanding of what the issues are, or it's impossible. If I were wearing a hat, I would take my hat off to you. But
well, thank you, sir. Kind words, but you can get all the expertise you need just by reading articles like this. So until then, thank all of you in your different countries and different time zones for joining us. And until next time, thank you very much, and keep reading Tax Notes.